Good evening to all of you. Continuing from where we left yesterday, we were dealing with the distinction between a sub-agent and a substituted agent is, it is said that a sub-agent works directly under the control of the principal. Sub-agent is responsible to the agent and not to the principal, but substituted agent is respondent to the principal. First and foremost, the first distinction is that as far as the sub-agent is concerned, sub-agent is appointed by the agent and he works directly under the control and supervision of the agent and not the principal, and is responsible to the agent. But as far as the substituted agent is concerned, he is an appointee of the principal and is directly responsible to the principal and not to the agent. That is the only distinction between a sub-agent and a substituted agent. Then liability of the original agent is for the acts of the sub-agent, the original agent is responsible to the principal, but for substituted agents, the agent is not responsible to the liability to the principal. So as far as the sub-agent is concerned, since he is an appointee of the agent, the agent is responsible for all the acts and deeds of the sub-agent who works directly under the control and supervision of the agent. But as far as a substituted agent is concerned, since he is an appointee of the principal, he is responsible only to the principal and not to the agent. And the responsibility liability is that is as far as the agent is not liable for to the principal. So whatever acts is done by the substituted agent is responsible and liable to the principal. But as far as the agent is concerned, he is not concerned in any way with the acts of a substituted agent. Then that is what all we have done yesterday. Today we go to section 192, where a sub-agent is properly appointed. The principal, as far as the third parties represented by the sub-agent, is bound to third parties for his acts as if he were the agent originally appointed by the principal. So, as far as the sub-agent is concerned, who works directly under the control and supervision of the agent, the sub-agent for all his acts and deeds and the liabilities, he is responsible to the third parties and as far as the as if he were the agent originally appointed. So the question is, for all practical purposes, a sub-agent is also an agent and he is responsible himself for his acts, liabilities to the third parties and not to the principal. Then we go to section 193. 193 is agent responsible for sub-agents. Where an agent without authority appoints a sub-agent, he is responsible for all the acts of the sub-agent. So the question is, with authority, of course the question of agent is liable. But as far as without authority, if a sub-agent is appointed by the agent for all the acts of misdeeds, fraud, etc., liabilities, etc., committed by the sub-agent, the agent is responsible for all acts and the principal is nowhere responsible for that. That is what 193 says. Then 194 is an agent holding, that is 193 is without authority. When a sub-agent is appointed, then the agent has to face the music, not the principal. Then 194 deals with an agent holding an express or implied authority to name another person to act on his behalf, act for the principal on the business, but he is not a sub-agent, but the agent of the principal for some part of the business of the agency as is entrusted to him. So, a substituted agent who is an appointee of the principal directly, an agent is not responsible for his acts, and as far as the substituted agent is concerned, he is responsible only to the principal concerned. That's what 194 speaks about. Here, there is an example that is given, sir. A directs B, his solicitor, to sell his estate by auction and to employ an auctioneer for the purpose. B names C and company an auctioneer to sell the estate. It is not a sub-agent, but is agent for the conduct of the auction. Here, A directs B to sell his estate. Then what B does is he appoints C and company a reputed auctioneer to auction the property and sell the property. Here, the question is here B names C, an auctioneer, to sell the estate. He is not a sub-agent, but he is an agent of the principal or the conduct of the business, because he comes directly in contact with the principal whose estate has to be sold. But he is the agent only, has been asked to name a person, and agent has named a person, and such a person who is appointed as an auctioneer for all his acts and deeds, because he is an appointee of the principal, he is liable to the principal. Agent is nowhere responsible for it, and an auctioneer is not a sub-agent, but at the most you can call him as a substituted agent. Then 195 deals with agent duly to name such a person as an agent, as an agent, uh, appoints a person without the authority to act as sub-agent. The agent towards such person as the relation of a principal to an agent, and is responsible for all his acts within the to the principal and third parties, and principal is not responsible for the acts. Suppose an agent without an authority to appoint a sub-agent appoints a sub-agent, it does so as his peril, and whatever acts and misdeeds are done by the sub-agent, the agent is directly responsible for the principal, and he is answerable for all the acts and deeds done by a sub-agent who has been appointed by the agent without the authority of the principal. Then in that case, the principal is not responsible in any manner. Then we go to 196, where acts are done by one person on behalf of another, but without his knowledge, he may elect to or ratify or disown such acts. Suppose certain acts have been done without the knowledge of the agent, and the sub-agent does it, then he does not inform the agent. For all acts and deeds done by the sub-agent without informing or without bringing it to the knowledge of the agent is not responsible. The sub-agent is directly responsible. That is what 196 speaks about. Then 197, ratification may be express or implied. What do you mean by express or implied? Means it can be reduced to writing, or it can be by implication, it can be by custom, it can be by trade, it can be implied that such a person has been appointed or has been given what is called the authority to deal on behalf of the principal. Here 197 says that here another, but without the knowledge he may. So the question is, suppose any act is done by the sub-agent without the knowledge of the agent or without informing the agent, and certain misdeeds are done by him, the sub-agent alone has to face the music, but the agent is not responsible in any manner whatsoever. That is what 196 says. 197 says ratification may be express or implied. Here, that is A without the authority buys goods for B and then sells them on his own account. B's conduct implies a ratification of the purchase made for him by A. Here, A without B's knowledge buys goods. That is, A without authority buys goods for B and then sells them as his own account. B's conduct implies, suppose let us say some other person is dealing with your goods, some other person is selling your goods, some other person has not been given the authority to sell your goods. But if he does so without your consent, without your knowledge, then the question is, it is left to you whether to ratify such act or not to ratify such act or to disown such act. That's what section 197 says. So anything done without the knowledge of the agent has got the right of electing to ratify or to disown the acts done by the sub-agent without his knowledge and concurrence. That is what 197 says. Then 198 says that knowledge requisite for value for valid ratification. No valid ratification can be made by a person where without whose knowledge is materially defective, unless the person ratifying opts to take charge. So, for ratification to be valid, for ratification to be subsisting, for ratification to be enforceable, or ratification to take effect, or to be true, it is practically necessary that everything should be done with the knowledge of the agent. If it is done without the knowledge of the agent has got the right of electing either to ratify it or not to ratify it or disown it. So the question is, anything done without the knowledge of the agent by a sub-agent is not binding on the agent, but the agent may ratify such acts provided he has knowledge of it, or he can disown it at his own option. And these are the two options that are given to an agent for the acts done by the sub-agent. Then we go to 199, sir. 199 deals with what is called effect of ratifying an unauthorized act forming part of the transaction. So, what is the effect of ratifying an unauthorized act, sir? Everything has to be done in an authorized way. Just because authority has been given, it doesn't mean that you can take things into your own hands and do it in an unlawful way. Suppose anything is done in an unlawful way, in an unauthorized way, the ratification will not have effect, and the agent will be responsible for all the acts and deeds done by the sub-agent. That is 199. Then 200 deals with ratification of unauthorized act cannot injure third persons shall be punished for such false. Suppose, let us say, sub-agent makes a false statement, or let us say he does an unauthorized act. Just because it has been ratified, just because it has been ratified by the agent subsequently, any injury that is caused to a third person, the agent and the sub-agent both have to face the music. That's what section 200. Then the next chapter is termination of agency. That is 201. Revocation by principle. How it is terminated, sir? Revocation by principle. Renouncing that is revoking the business of agency or initiating the business of agency being complete, or by the death of principal or becoming unsound mind or insolvent. Suppose the principal is a minor, or principal becomes unsound, or principal suffers insolvency, then in that case the agency comes to an end and it is normally revoked, terminated. Then we go to 202. Please remember, this is a very important chapter. That is what is called agency by necessity. See, most of us today, in our day-to-day life, we are giving our old buildings to a builder for the purpose of construction, right? And then the builder has to take the necessary permission, he has to take the necessary clearances, he has to take the necessary permits, he has to use his financial resources, he has to raise money for the construction, he has to build up a corpus fund for the purpose of construction, he has to look for prospective purchasers, and then the entire thing is done by the builder. And under the contract of development of the property, the because the agent employs his own funds, his own finances. He does the liaison work. He takes the permits. He takes the clearances. He takes the sanction, or does all the spade work which is necessary for commencement and completion of the project. Then, in that case, a development agreement is drawn out between the principal and the agent. Agent is none else than the builder. That's why it is coined as development agreement come general power of attorney. Please remember, no one can develop a property of some other person unless he has got authority or sanction or permission of the real owner. So, to do all those things, he requires power, he requires authority, or he requires a permission. So, that is the reason development agreement come general power of attorney is normally executed. What does it mean? General power of attorney means the builder is given all the powers to approach the government, to approach the local authority, approach the HMDA or the Urban Development Authority, apply for permits, apply for clearance, apply for layout, apply for building permission, so on and so forth. And he has to do the necessary spade work. And for that practical purpose, he has to spend money. And that is the reason no one does anything free for anyone. So when the construction is started, the entire finances are made by the builder. He raises money by whatever source you like, and then when the development agreement is drawn up, it is said that the builder is entitled for 60% of the share of the completed flats or completed shops, and the owner is entitled for 40%. What does it mean, sir? Once the complex is constructed, be it a residential or a commercial, the builder is entitled because builder becomes the owner to the extent of 60%, and 40% will go to the owner. And that is the reason what they do in the development agreement itself. They say whether it's going to be a five-storied complex or a six-storied complex, and they also decide how many flats are going to come, how many shops are going to come. Then in that case, they fix the sharing ratio. Here, the builder acquires an interest in respect of the immobile property, right? And then he is entitled for 60% of the built up area. What does it mean? He has got the right, he has got the authority to sell that 60% to the prospective purchasers and then get his money as far as the cost of construction is concerned. And in that respect, he requires the assistance and cooperation of the owner for all practical purposes. So, for that practical purpose, the power of attorney is also and the sharing ratio is also mentioned. Which flat is going to be allotted to the owner share, that is a 40%, and what is going to be allotted 60% to the builder. So what they do is, normally commercial premises are concerned, the builder retains his right as far as the commercial premises are concerned, because the returns which you get in respect of the shop by way of pagadi, by way of goodwill, or by way of whatever advance or whatever you may call, the question is it is far high. That is the reason no builder will part with the shops in the ground floor. And as far as the stilt is concerned, where it is meant for parking area, the question is parking is allotted to the different purchasers on the payment of on the payment of what is called fees, or the money is also collected for parking, and certain space is given to you, given to every owner who purchases a flat in that particular complex, and that we clearly mentioned. That is 220 square. I think if I'm correct, is 220 square feet or 250 square feet will be given to every flat owner who pays the money for purchasing that flat area. And one more thing, under the building regulations, no construction should be made in the ground floor or in the stilt rather, which is meant for parking. It is meant only for parking. No commercial activity can take place in the parking and does not belong to anyone, but belongs to the individual allottees who purchase the property on payment of money. So the question is, to do all these things, to apply for permission, to apply for sanction, to apply for clearances, and to apply for government permission for the purpose of commencement and completion of construction, and also to raise finances by way of loans, etc., etc. It is done by the builder. So for that, he requires a power of attorney, and power of attorney is nothing but a mukhya nama, as they call it. That is a power that is given to the builder to apply for permissions for and on behalf of the owners of the property, and then also obtain the necessary clearances, necessary sanctions, or also mobilize the funds and look out to prospective purchasers who are going to purchase the property. All the spade work is done by the uh, by the by the builder. So that he requires a power, he requires an authority on behalf of the principal to do all acts and deeds what the principal himself would have done on his own. So for that, a general power of attorney is also executed. That is why it is said development agreement come power of attorney. That means a builder who acquires an interest in respect of immobile property and he has a share in the immobile property, his interest is not defeated because of the death, because of the unsoundness, or because of the insolvency of the owners. That is why it is called agency by necessity. Agency by necessity means where the builder acquires an interest in immobile property by virtue of a share in the immobile property, his interest does not get defeated by death, by insolvency, or by unsoundness of mind. Normally, in all circumstances, our understanding is once the person dies, once a person becomes of unsound mind, or once a person becomes an insolvent, the interest of the power of attorney also comes to an end. No, sir. Once the builder or the once the attorney holder acquires an interest in immovable property, an agency, whether the principal likes it or not, is created by necessity and it cannot be defeated by death, insolvency, or unsoundness of mind. That is what section 202 lays down. This is why it is called agency by necessity. Then we go to what is called 203. 203 says that the authority can be revoked before the authority has been exercised so as to bind the principal. So the question is the authority given to an agent to act on behalf of the principal can be revoked, can be renunciated, can be taken back, or can be avoided before the agent commences his work, starts his work, or he commences his work in consonance with the authority that is given to him. Then, in those cases, the question is the authority can be revoked. That's what 203 says. 204 speaks about revocation where authority has been partly exercised. The principal cannot revoke the authority which he has partly exercised, or as such acts and obligations arise from acts already done in the agency. Please remember, sir, construction, that is పెళ్లి చూసి చూడు ఏది ఇల్లు కట్టి చూడు అంటారనమాట. So the question is, when a builder has used all his resources, when the builder has used all his experience, when the builder has raised funds, he has identified the prospective purchasers, he has obtained the clearance, he has obtained the sanction, he has obtained the permissions. When all these things are partly exercised and even the prospective purchasers have paid advances in respect to the flats which they want to buy, please remember, under those circumstances where the authority has been partly exercised by the agent, that cannot be revoked by the principal under any circumstances. That is what 203 says. 203, 204, I'm sorry. Here, 204 says revocation where authority, and the next one is such acts as obligation. Please remember, sometimes why this provision is made is the builder or the third party or the agent, based on the representation made by the owners, enters into a development agreement, come general power of attorney, whereby he derives his authority, and by virtue of that authority, he does the liaison work, he purchases building material, he raises funds, he obtains permissions, he obtains sanctions, and he identifies the prospective purchasers and receives advances also from the prospective purchasers towards his share. Then in that case, what happens is that cannot be annulled, that cannot be revoked, that cannot be taken back by the principal under any circumstances, and that is the purport of section 204. Here, A authorizes B to buy 100,000 bales of cotton on account of A and pay it from out of A's money remaining in B's hands. B buys the 1,000 bales in his own name so as to make business personally is personally liable to pay. A cannot revoke B's authority so far as the payment for the cotton, vice versa. Here it is said A authorizes B to buy 1,000 bales of cotton on account of A and pay it from out of the money remaining in B's hands. B buys 1,000 bales in his own name so as to make a business of make a business or personally liable for the for the law for the here. Suppose let us say A is given authority to B to buy goods, and the goods have to be bought in the name of A, and out of the funds available with B, which belongs to A. Then what B does is he purchases the 1,000 bales of cotton not in the name of A, but purchases it in the name of in his own name. Then in that case, it is said that liable for the uh, price. Here, as far as the price is concerned, B is liable to pay the money as far as the 1,000 bales of cotton is concerned, and also compensate the principal who has given him authority to sell. That's what 204 lays down. And A cannot revoke B's authority so far as the payment for the vice versa. Here, as far as the payment is concerned, B makes the payment from wherever, whichever source. If anything excess B has paid, he is entitled for compensation to be paid by A towards the excess price. Here, B buys 1,000 bales in his name. A can revoke the authority to pay for the cotton. Here, A buys cotton. A authorizes B to buy cotton. Then let us say B does is before the authority is exercised, before the power that is given to B is exercised, A can revoke the authority. But if the goods are already purchased, A has to pay for it, though B has purchased it. That's what 204 says. Then 205 is where there's an express or implied contract that the agency should be continued for any further period. The principal must pay compensation to the agent and the agent to the principal for any previous revocation of the agency without sufficient cause. Suppose, let us say, either the principal or the agent, without any sufficient cause, revokes the agency, terminates the agency, either of them who is at fault, and without notice it has been done, either of them, be it the principal or be it the agent, should compensate each other for the unlawful acts. That's what 205 speaks about. Then 206 is notice of revocation must be given. If not, compensation by principal to the agent has to be made. So please remember, revocation cannot be made in the sky. Revocation cannot be made orally. Revocation cannot be made as per your whims and fancies. You have to show sufficient cause, and revocation must be done by following the due process of law, and it must be duly communicated to the agent. But if the revocation is made without notice, the principal has to compensate the agent for the loss which has been caused because of the unlawful revocation. That's what 206 speaks about. Then the illustration 207 speaks about revocation may be expressed or implied. Afterwards, A lets it out to be here. Revocation may be expressed or implied. Suppose, let us say, what do you mean by express or implied? It can be in writing or by implication also it can be inferred. For example, A authorizes or empowers B to let out his house, right? What is the authority given to B? To let out A's house. But subsequently, A changes his mind and occupies the house himself. Here, what happens is the agency automatically gets revoked. A, that is, here it's a revocation may be expressed. So, by implication, suppose A himself occupies the property and without it being let out, and B's authority automatically comes to an end. That is what 207 speaks about. Then 208 is the termination of authority, not as far as regard the agent takes effect, but it becomes known to him as for the third person before it becomes known to them. So before the third parties know about it, know about the revocation, know about the termination, the agent has to be informed, agent has to be duly communicated, and before the third parties know about it, this thing has to be done. But if it is done without the knowledge of the agent, the principal has to compensate the agent for for the revocation done unauthorizedly. Then A directs B to sell his goods and agrees to pay 5% commission. The sale is binding and B is entitled to 5% commission. Here, let us say, sir, no one does anything free of cost. Everyone does it subject to subject to his being remunerated. So, for that practical purpose, what happens is the principal says, "You please sell my goods and get a good price. I will pay you 5% commission." Please remember, if B sells the goods, the question is A cannot say, "I will not pay you the commission." Who asked you to sell the goods? B can say, "Sir, you have authorized me, you have empowered me. By implication, you have authorized me to sell the goods. I have sold it. By my 5% commission, you will have to pay." So, whether you like it or not, the principal has to pay that 5% commission to the person whose services have been engaged. For example, today we have got lot of real estate agents. They can get you the property for sale. They can buy, they can by the project. They can look to purchasers on your behalf, and then once they arrange for sale of your goods or sale of your mobile property or immobile property, they charge their commission. No one can dispute it. And as far as rented houses are concerned, I was told that 1 month commission, 1 month rent is collected as commission on the side of the tenant, and 1 month's rent is collected from the owner of the property. And please remember, when you hand over the property to a realtor or a person who looks for rental people or rent, then in that case, without charging their commission, no one would render those services. Then if you want to purchase a second-hand car, then in that case also the person who sells the car or the person who is engaged in selling second-hand cars, then in that case, if you are going to be the second purchaser, the question is who is the seller, you do not know. But the person who is holding the car sells the car to you on or brings about a contract between you and the actual owner of the goods, and then he charges his commission, whatever is permissible under the rules and regulations governing their area of business. Then you find people in the RTA doing some jobs for you, brokers as they call it. If you call broker, they'll hit you. You will say agents. These people also are engaged in the process of getting your car registered, getting a number to your car, or let us say do the necessary spade work in the RTA department and do all those things which you would have done personally. Even to obtain a license, also you engage brokers and they do it. And then for that they charge their service fee, and that you are supposed to pay. And under no circumstances you can avoid. In those circumstances, they become your agent and you are the principal. The last aspect which I'll discuss and then close is the question is the termination of the authority of uh, the agent causes the termination of the authority of all sub-agents. So once the agent goes, once his authority is revoked, once his authority is terminated, all the sub-agents also go along with him. Something like a tenant and a subtenant. Once the tenant is evicted, all the subtenants also who are inducted into possession by the tenant, they also go out of the property. This is the effect of section principle. According to the directions, according to the customs which prevails in the doing the business of the same kind where the agent conducts such business. So whatever business is conducted by the agent, it should be for the benefit of the principal and should be under the authority of the principal, and you should have the implied consent as far as the principal is concerned to do that business, and whatever business is done by the agent for and behalf of the principal should be in the best interest of the principal, and the interest of the principal has to be safeguarded in all respects, and no, as a prudent man would conduct the business in a similar way, it has to be done. This is what section 211 speaks about. So today we have dealt with from section 192 to 211. In the next class, we will deal from section 212 to the end of law of agency, and also give you the kinds of agency and kinds of agents and kinds of and what are their duties and what are their liabilities. Thank you.